It's alleged that you assaulted Taylor Marie Hall, a resident or former resident of your household, and Andrew Michael Hall. Who are those people to you?
Taylor is my girlfriend and Andrew is her father.
All right, and also a charge of interfering with a crime report. According to this, you're going to plead to one count of interfering with a crime report and one count of domestic violence by way of a no contest plea. Ms. Stoll, is that your understanding?
That's correct, Your Honor.
You agree, Mr. Gibson?
Yes, Your Honor.
All right, well, let's talk about that, Mr. Carr. Is this deferral eligible?
That's the offer.
All right, with a deferral. All right, well, let's talk about that. Interfering with a crime report is punishable by up to a year in jail and a fine of up to $1,000. Domestic assault is a misdemeanor, punishable by up to 93 days in jail, and a fine of up to $500. It would prohibit you from using or possessing a firearm. The prosecutor is offered to do a deferral. And if you do a deferral and you do it successfully, it won't result in a public conviction. They'll keep a private record of it, and it wouldn't have the firearm restriction. I don't know if you hunt or target shoot but it's important to some people to have their firearm rights. You also indicated you're going to plead no contest to this charge. The last guy just did this. By pleading no contest, you don't admit what happened, you don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Yes, Your Honor.
Is that what you wish to do here?
Yes.
Anybody threaten you to get you to do this
No, sir.
or promise you anything?
No.
What do you do, Mr. Carr?
I work at a plastic factory.
Which one?
Cutter's Associates in Sturgis.
All right. What do they make?
Big plastic sheets that get cut out and filters go in them and they go to a farm.
All right, according to the booking and bond information, this happened on December 7th. They were dispatched to, looks like Memory Lane Mobile Home Park, lot 142, made contact with Andrew Hall. His daughter Taylor Hall called him because Clayton Carr was punching holes in the walls. Once there, Clayton became confrontational at the back door and prevented Taylor from leaving. So she climbed out the window. Clayton came out in the driveway and tried to push Andrew off the property. Andrew called 911, at which point Clayton smacked the phone out of his hand. Clayton continued pushing, at which point Andrew wrapped his arms around Clayton and Clayton punched him. It doesn't show whether alcohol was involved. Had you been drinking?
Yes, me and my girlfriend had got into a fire at the bar.
All right, so that's the reason for no contest. Which bar?
Route 12 in Sturgis, they just opened up.
What's it called?
Route 12,
Route 12. Where is that?
it's on US 12 and the people who just bought it, their
Is
last
it the
name
old
is
Hilltop?
Yeah, the old Hillcrest.
Hillcrest. Dismiss the A and B. Normally, in a domestic violence case, I would set it out for sentencing at least 10 days. Let's take a look at your motion. Defendant and Taylor Hall are both on a lease and buying a home together that they had lived in for approximately 18 months. Is that the trailer on lot 142?
Yeah, we haven't lived at that address for 18 months. We've been together and living together for 18 months and we're just now buying that place.
All right, so
within the
you've got
past
a
3
lease
months.
option to buy that trailer.
Yes,
Defendant's attorney was contacted by a person that said they were Taylor Hall. She wants the no contact provision lifted. I haven't actually heard from Taylor Hall. Do you have children together?
no, we don't.
Where are you staying?
I've been staying at my mom's house in Bronson.
How old are you?
22.
This goes under the category of you don't know what you got till it's gone. When they prohibit you from having contact with your girlfriend, kind of makes you appreciate what you're missing. I'm unwilling to amend the bond based on that. We don't know whether it was even Taylor that called Mr. Gibson. Do you have any input regarding that, Ms. Stoll?
I would object to lifting the no contact order, Your Honor.
What we will do, however, Mr. Carr, is set this for sentencing as soon as we can. One of the reasons, well, the main reason is to protect the complainant. We don't want further assaults or worse pending a trial. Another reason is to protect the complainant from coercion to get her to change her story or withdraw the charges. Well, we don't have that problem because you've just admitted a plea of no contest. So I'm less concerned about her testimony, but I want to know what her input is. So I'm going to have to squeeze this in somewhere. You don't have any children together. You're employed. You've got a place to live. We can try to get this done in the month of January.
He is also on bond for a,
Yes, he has an OWI case with,
Oh, let me look at my cheat sheet.
There was no bond conditions for that.
Yeah, you're on bond for operating with the presence of a controlled substance set for last pretrial on 1/22. Do you represent him in that as well, Mr. Gibson?
no, I believe he has Attorney Strong.
Well, let's look at January 22nd. Thank you, Deborah. Trying to see whether you're set to be here that day. Oh,
I think,
he filed a motion regarding setting bond conditions in that case, and the defense responded,
in the drunk driving case?
yes. But it doesn't look like there's been a motion date set.
Well, Paul, can you be available at 2:30 on the 22nd to do the sentence in this matter?
the 22nd,
Yeah, Thursday, January 22nd.
yes, it looks like it can.
Thursday, January 22nd at 2:30. Need victim input, police report.
We would indicate that somebody saying that they were the victim called and inquired about having the no contact lifted. And our victim advocate advised they could talk to the defense attorney. So I'm not doubting that she has requested that, but we just don't have any confirmation.
All right, fair enough. All right, you guys are gonna appreciate what you're missing between now and January 22nd. Now, this isn't good. You got a DV and an OEYL in short order. Apparently there's some sort of a bond motion in that case. I don't know what the status is, but we're gonna set this for that date. I'll give you a handwritten notice. You may get a more formal one, but you're living at your mom's. I appreciate your patience. Somebody always ends up being last. Today, that was you. Thursday, January 22nd, 2:02:06. I'm back, January 22nd. Yes. All right, now, your bonds, no drugs, no alcohol, no content with a complaining witness, no assaultive or threatening behavior. So try to keep it together. I will see you on January 22nd. We'll deal with this and possibly your other charge, but that's in front of Judge Patterson. So do you have any questions? All right, you're good to go.
So he doesn't need to talk to the probation department or anything?
No.
Okay.
Thanks. Thank you, Abigail. You got a short lunch too.
Are you done with all these, Judge?
No, I need to look at them. Who are you looking for?
He's put on, I think, for disturbing the peace.
Oh,
Probably this one.
yeah, that's him.
Can I take this one?
Yeah.
Okay.
Are you all done, sir?
Yes.
Oh, finally empty now. Whew. What a morning.
Yes. All right. That took till 12:35. We got a short lunch and then we got some civil matters at 1. All right, everybody that was sitting through this, thank you. That is our busiest morning of the month. We took about 16 pleas by my count. Have to go back and reconfigure.